Hello and welcome to this event, Courts and Technology, as a part of the Victorian Law Week. I would like to begin by acknowledging the traditional owners of the land from which I am speaking, the people of the Kulin Nation. I pay my respects to their elders, past, present, and emerging. My name is Nathan and I'm the Manager of Court Technology here at the County Court of Victoria. Before that, in my previous life, I was also an associate to Judge Tsalamandris here, in fact. If any of you have any questions for the panelists, you can type them in the Q&A box at any time during the event. I will then relay these questions to the panel later in the event. Please note that we have a number of people participating in this event and we may not be able to answer every question. Our panelists are Judge Tsalamandris, Judge Marks and Judge Marich. I'll hand over to them briefly to introduce themselves. Judge Tsalamandris.
I'm Judge Tsalamandris. I'm the head of the Common Law Division of this court, so we hear cases involving personal injuries and defamation law, and my interest in IT is, I suppose, when I came to the court, I thought that I needed to embrace it. I'm going to be here for quite some time. So two of the things I've done early on in my time here at the court was using electronic court books. Is something I started doing about 4 years ago. And then last year before COVID, I was fortunate enough to trial running a jury trial with iPads. So they're probably two things worth noting, given this is a technology session. So that's me.
My name's Martina Marich. I'm a judge that sits in the criminal list in this court. I don't have Judge Tsalamandris' background in technology, so while I had some basic competence in using technology in the court before I was appointed, I think that I've had a crash course in using technology, particularly in the pandemic, the requirements that the pandemic has forced upon us in the last 12 to 15 months. I'm now a bit more proficient than I was before the virus rolled in. Judge Marks?
Yes, I'm Samantha Marks, Judge Samantha Marks. I sit in the commercial division, so we deal with all sorts of matters where people are suing each other over money one way or another. And before that, I was a barrister for 27 years. And my very first year as a barrister, I went out and spent an enormous amount of money on a computer that was extremely heavy, but it was a laptop, and everything came up orange. It was one of the first DOS type computers, because I thought this is going to be the way of the future. And I still remember lugging it back and forth from home, being amazed I could type things up and there it would stay. So I've had an interest in technology throughout. And it's been very exciting to see what the court has been doing with technology, both before the pandemic and now.
Thank you. Okay, I've got a couple of questions for the judges to start the conversation, but again, please feel free to type your questions into the Q&A box at any time. Just a reminder that our panel cannot give any legal advice or comment on specific cases. So the first question for Judge Tsalamandris. How has technology in the justice system changed during your time of the court or while working in the law?
Well, certainly for me, the move from paper to electronic court books has been probably the biggest change that I've seen, certainly pre-COVID. So when I first started practice, and even when I came to the court, we would have folders full of court documents, and in a trial, depending upon the length of the trial, you could have folders and folders of documents. I remember going to watch at times Rebel Wilson's case, in the defamation case in the Supreme Court, and the jury would sit there and they'd have multiple folders piled up, and counsel would say, go to this document or that document. There'd be shuffling of papers and folders. So about 4 years ago, we had the opportunity to pilot an electronic court book trial here, and I've been doing it ever since. So now I carry my device, and no matter how many documents are on it, I can have everything there. So whether it also means working from home, obviously, is easier, but when I'm in court, I can very quickly move within documents, and I can mark up documents as if it's paper. And that, in some respects, maybe that doesn't sound that radical, particularly if there's secondary school students watching. They'll think that's the norm, but it is a pretty big change for the law. But it's a change that I think has resulted in a lot of efficiencies in my courtroom, and certainly has probably saved a lot of trees.
Thank you. Judge Marich?
So my experience over the last, let's say, 15 years has shifted, like Judge Tsalamandris', very much from paper to the screen. We found a number of changes that have been made incrementally has meant that you could learn and adapt to each technological change before you move to the next. I think the first big change was in Victorian criminal proceedings. About 10 years ago, the Victorian Office of Public Prosecution started serving its depositional material, which was all of the material that they had to disclose ahead of time, electronically instead of in paper form. Now, that was life-changing for simple reasons, such as those that you described, Judge, including the fact that you didn't need to lug documents around. And also, as time went on, we started thinking less. I used to have to see something physically in order to be able to process it and see the way that it all linked together with the rest of the evidence. But as time went on, I became more adept at making those linkages on a screen instead of having to lug it all around. And then more recently, we've encouraged, or I was going to say we've encouraged, at the time that the court encouraged parties, including defence, to start filing documents electronically ahead of time. I was still in defence. So we encouraged or were encouraged to start filing electronic versions of documents, even that the accused would be relying on ahead of time. This is particularly so where a person is pleading guilty to a charge. In the olden days, now 10 years ago, 5 years ago, the defence would turn up to court and hand 20, 30, 100 pages of reports to the court. And the judge and the prosecution would be at that disadvantage in trying to synthesise enormous amounts of information on the spot. So for me, the last significant change before we turn to pandemic era is by filing documents electronically ahead of time. It just allows everyone to collect their thoughts so that the court time is spent refining the fine points instead of everyone scrambling to catch up with the details.
Thank you. Judge Marks.
Well, I'd agree with both the things that have been said. I mean, I have specific recollections of starting out in the law, and every time you went to court, you either had to take trolleys full of information across with you and then back across the road again afterwards. You had all your books piled up as well. And of course, that will show what a dinosaur I am. But the fact is that in a lot of courtrooms still, and that kind of thing may still be happening. But I think what the pandemic has done is made a lot more judges, lawyers, and those attending court a lot more comfortable with doing things electronically, which is what's happening across society in any event. And I certainly think that there have been huge savings of time and therefore of money for the people who are coming to court and having to pay for those things being done.
Thank you. Okay, I think something everyone will be interested to know is how each of you found the court transition to online hearings in the wake of COVID. Can you give us some insight into how you found the transition to virtual hearings, Judge Tsalamandris?
Well, I sit in the Common Law Division, so we had at the beginning of the pandemic, well still, but anyway, 2/3 of the judges in the Common Law Division were over the age of 65. And so the immediate challenge, I think, when we had to either shut down the hearing of common law cases in person, because that wasn't possible in COVID, or to adjust to hearing cases remotely, the immediate challenge for me as head of the division was, how do I get people that aren't familiar with computers? There were some judges that didn't have a computer, some judges who in their homes had no internet. So within a 2-week period, people adjusted, and it was amazing. People in this court and the profession, everyone just wanted to be able to get on with hearing cases. And so what seemed impossible, and I think that the change that was achieved in that 2 weeks, if not for the pandemic, would have taken 5 years or more. But suddenly people got their head around appearing remotely, having evidence heard that way, having witnesses sworn in, sharing documents on the screen. And it happened with tremendous speed because everyone was motivated to keep the wheels of justice going, and particularly in the Common Law Division, where cases, for example, where it was a jury trial, they were able to proceed as judge alone without any change in legislation. So it ultimately meant that we heard the same number of cases last year as we did in the year before the pandemic. So there was a 2-week period of lots of adjustment and quite a number of judges freaking out with a computer, what do you mean? But it happened quickly, and it became the norm very, very quickly.
Okay, the story in crime is not quite as quick or happy as that. So I'll start with the condensed version and try not to let any of the anxiety or the lack of nostalgia about dealing with crime in the pandemic creep in. Firstly, we started by doing exactly as Judge Tsalamandris found in the common law list. Firstly, we tried to fragment the parts of the criminal list that could keep going remotely from the parts of the criminal list that couldn't keep going. And there I'm talking about jury trials. At the time that the pandemic rolled in, now let's say 14 months ago, in Victoria, we didn't have any capacity to resolve criminal trials except by jury. So they couldn't be resolved through some technological fix. So for about 8 months of last year, we couldn't conduct jury trials. The Parliament introduced trials by judge alone, which could be dealt with in part via technology. But for the first few months, it was somewhat bleak because we had so many matters that started to accumulate that we couldn't resolve in any safe way during the lockdown and immediate aftermath. But the happier part of the story relates to the parts of the criminal list that we could actually keep going with. So that included the pleas of guilty, where what issue existed for determination by the judge was sentencing. They moved very comfortably to online. And in fact, the practices that were developed during that period are still intact. That was what I was referring to before in terms of exchange of volumes of information and documents ahead of time. The accused was a participant on the screen, the same as the barristers, the same as media, if they were interested, the same as the trial judge. And we also increased management of the matters that started accruing in the trial list. So that was something that could be dealt with remotely as well in a very straightforward way. So if an accused had a trial pending, there might be pre-trial issues that could have been resolved that, of course, wouldn't have needed a jury. And so judges at home and from chambers, if we were permitted to do so, those matters could keep going. Let's just say it wasn't the happiest time for people to be charged in that list, for people to be advocating in that list, and also for people to be judging in that list. But like in the common law experience, we got through as many sentences as we would ordinarily. In fact, I think we did a few more. Plus, there was the advent of all of this case management. And so the judges were engaged productively, but it was a different form of work than it was previously and that it has been since. Hopefully the commercial list experience wasn't quite as bleak as that.
No, I think we were far more like the common law area. Look, initially it was it was an overwhelming time, wasn't it, for everyone? And across the board, everyone was trying to work out, what does this mean for us as a society, let alone in work? I know that judges that I spoke to overwhelmingly felt that they wanted to keep everything going as much as possible, and there was a great deal of hard work put into that. And similarly, the lawyers and those appearing. From the point of view of the commercial division, we were very fortunate because the court had already put a lot of work into improving the technology that our court had, very ably headed up in the year or so beforehand. We even had new computers and all sorts of things that I think would be envy some of the other courts. But nonetheless, there was a lot to get across quickly. Initially, some of the more minor sorts of matters were dealt with by agreement with the parties on the papers. They put in their written submissions, but very quickly we were working out Zoom hearings and how to do those, and becoming very proficient in having court books and so on that were prepared. We'd had those already electronically, but everyone hadn't been using them. We were working out how to share screens and do all of that. And I think we were getting through very quickly 90% of the work we'd got through beforehand, and there was never we never got behind in that sense. So I think I echo what Judge Tsalamandris has said, in that there's been about probably 5 years worth of advances within a few months, and a lot of people have become a lot more comfortable with how to work electronically as a result.
Absolutely. I should
just add, and I'm sorry to interrupt, Nathan, in terms of what was it like at the beginning, there are a couple of personal things I thought were quite funny. One is that I was still getting used to the fact I had to get dressed in my robes whilst I was in my study at home. That felt very strange initially. And I wandered out to get a coffee and a break while the barristers had gone off to talk to each other and the case was stood down, and ran into one of my children, who was also very surprised to see me dressed up in this way on a mid-morning. But they're totally used to it now.
Thanks, Judge Marks. I think another thing to highlight as well is the fact that the court was able to hear, over the last 14 months, just over 14,000 hearings remotely by both WebEx and Zoom, which is an impressive feat, really.
Wow.
Another question for you judges is, have you had any examples of technology bloopers in the past year that you can share with everyone?
Oh, well, bloopers, the unmute, I think we've all got used to saying you're on mute, unmute yourself. But I think my blooping highlight that I have a son in year 11 and, well, last year he was in year 10 and probably typical of many year 10 students, he quite liked gaming. And so at the end of his remote learning, at the end of the day, he would start his gaming and I would be in the front room of our house in my robes in court. And I think the important part of what we did last year was always the challenge to maintain the solemnity of the courtroom. Giving evidence in court is a very serious matter. We would have the virtual background. So Judge Marks there has got a virtual background. Who knows the chaos that might be behind her in her house.
Thanks,
she might have,
Judge Tsalamandris.
I was going to say, you might have a calm house. In my house, it was pretty chaotic. So anyway, I'd have the virtual background up. And my son thought that on the first day of me hearing a trial at home, when school finished and he thought he'd start gaming, he games very loudly and tells people who need to be shot on whatever game he's playing. And so I was trying to be very serious and quiet in the front of the house listening to. It was serious, all evidence is serious, but it was a particularly difficult time for the witness giving evidence. But I was stuck, just as you can see, Judge Marks now, you're on camera, couldn't do much. So I had to mute myself so that people in the courtroom couldn't hear my son gaming. And then at the end of the day, I went out and reminded him. He did it again the next day, but the next day I happened to have my phone with me. So I was able to mute myself, dial him, he could then hear the evidence and he never did it again. But that was probably my biggest blooper. But I think people, I mean, I had an occasion where a baby, a toddler walked in and counsel was addressing me in closing submissions and the barrister was very embarrassed, but I just said, look, we're all adjusting. I appreciate that you've got young children at home. We had to be flexible in those kind of things happening. So, yeah, how about you?
There are more. Seems like there were more bloopers than there was smooth sailing, especially to start. And though everyone was experiencing such anxiety about change, I think that it was we needed to sort of learn to have a game face pretty quickly. I had the same experience with Judge Tsalamandris in relation to having kids at home who were trying to study, who had to be quiet, who had to concentrate, who I became upset that they were using far more than their share of Wi-Fi that was justified because I wanted first, claim on the Wi-Fi. I think we all became experts at figuring out what were the stronger points of Wi-Fi throughout our house and the weaker points. You became conscious of every pet sound, every dropped cup, every plate. It was quite a stressful event, I think, for many because we were so conscious of the burden on family, the burden on pets. And also you can imagine the subject matter of quite a few of the cases that I was dealing with. There was a lot of stay in your bedroom, stay in your lane, don't listen to what I'm talking about. Although fortunately, I could remember one of the more experienced judges who was approaching retirement suggesting that I'd be passing a sentence and, one of my kids would give some editorial advice as to the appropriateness of the sentence. Happily, my kids never managed to offer any editorial advice before I managed to shut the link. But I think the upshot is that we quickly became more familiar with technology than I was comfortable with, and the importance of a wired connection. I don't think we can be reliant on Wi-Fi when there were that many demands being placed on it.
Yes, no, I'd echo all of that. Fortunately, we had just upgraded our home for fantastic Wi-Fi just before this happened. And when I saw what was happening over, so shockingly, in Italy and Spain and so on, I'd gone out and got a better screen. And so I have a variety of screens set up at home, and I have the iPad and I have the webcam and I had all of that. And my children were not school age, which made life simpler, though I did notice that around 4:30 every night, the Wi-Fi seemed a lot more dodgy. which I put down to all the other school kids finishing school and getting on to their gaming and everything else around the neighbourhood. My biggest blooper was once joining court with Hawaii in the background, which turned out that one of my kids had changed the screen. So I quickly just adjourned the court for a moment, and when I came back, one of the barristers just said, "Well, you look like you're in a much better place than us, Your Honour." And there was a time I came back from lunch, raced into my home study, put on my robe, and was just about to join the trial again when I realised I still had my mask on, which was possibly more social distancing than was required on the Zoom. So I took it off.
Thanks, Judge Marks. Okay, we have received an anonymous question, which I might ask each of you to provide a response to, please. Do you think technology will continue to shape the way in which lawyers and the courts deal with disputes going forward?
100%. I don't think we will look back. I think this has brought forward changes that would take some time. But yeah, I certainly think we'll just keep making advancements. I guess there are two things that are worth talking about in response to that. During COVID, it was something that we had planned pre-COVID, but certainly was developed during COVID and that will be continued to be improved in the near future, is the County Court of Victoria now has ability for people who receive a subpoena. So a subpoena is a document that you receive that requires you to produce certain documents to the court relevant to a court case. And so people that receive those subpoenas now can answer the subpoena electronically. And that's really important. So many documents now are in fact created in a digital manner. So medical practices, banks, the tax office, Medicare, pre us establishing this electronic portal for subpoenas, those institutions would need to print out the copies of those documents or send it in by way of a USB. So we've now got that portal that accepts those documents electronically. And that's an example of technology that certainly we moved that forward very quickly at the beginning of the pandemic. We're not going to look back for that. That will, of course, continue, and we'll continue to improve that portal, and there'll be other things that will go on to it. And I guess the other thing I'd mentioned earlier, I think that I had done an electronic jury pad trial where just like I love the benefit of having an electronic court book with all the documents there, we did a trial before COVID in the civil common law jurisdiction, and the jury all had electronic devices where they would look at the documents themselves and mark them up individually. So we've paused that for a period of time, but I think that will be another example of technology that we'll just continue to roll out across both the civil and the criminal divisions because of the efficiencies that come with it. So yeah, I don't think there's going to be any looking back.
So I think, speaking in relation to the criminal list, I've noted huge time savings where hearings that can be conducted remotely are conducted remotely. And thinking outside myself sitting in chambers versus myself sitting in court, to be an accused who might be in custody waiting for their matter to be heard, who needs to be brought into court each day. So many of the prisons are in outer Melbourne suburbs, some of them are in the country, and that was one of the pressure points that existed on accused in criminal cases who were on remand when their matter was being heard. Now, if that was a plea of guilty that might take 2 hours, it might mean that they were brought out, they were woken at 4, they might have an hour or 2 of transit, and the vehicle might stop at other prisons, it might stop at other courts on the way. It was physically gruelling before the accused would ever get to court. And then after the court hearing, the same thing in reverse. And you can imagine if an accused was in trial, then that would be repeated every day for 5, 10, 20, 100 days. So what we experienced by moving some hearings online, which could be heard online, was that the accused would have minimal disruption to their time, and they'd avoid some of the physical discomfort and the parts of the court hearing which were unnecessarily anxious and physically taxing. And I think that is a huge step that we couldn't have thought would automatically happen except when it was forced on us. And the other thing I think is, having regard to our experience and all having had small children at some stage, I think as an advocate, if I could have dialed into hearings instead of having to move from court to court to court. I can imagine that saving in transit time is one less of the responsibilities that a parent needs to undertake. And it's not just parents, it's people who need to organise busy lives. And I also think that where those hearings in the criminal list can be conducted online, the saving in transit time it is not as acute as in relation to prisoners, but is another of those huge nervous energy savings.
I would echo all of that. And I would say, obviously, there is always a place, and there'll continue to be a place, and an important place for in-person hearings or aspects of hearing being in person. That's so obvious, I think it goes without saying. But what I think has happened is we've become very aware that that's not every minute of every case, and that there are huge times and cost savings for people and other benefits as well in doing some aspects of it remotely now that we've got that technology. So I sit sometimes in our division where we'll just be dealing with lots of interlocutory applications. It's called duty court. People come saying, we need these documents for this case coming up, or we don't understand the case that's been pleaded as against us, or we want to have a decision about whether we can get judgment straight away without a trial, those sorts of issues. It used to be they'd all be listed at the beginning of the day and all the different lawyers, and often the clients would turn up and many of them wouldn't even get on for a few hours. Now I'll list things through the day and they join different Zoom hearings. And the worst that might happen is they might be told one needs to be pushed back a bit. I think all those lawyers, all those people who are involved can get on with other work as well. They're not having to charge their clients for as much time necessarily. I did a case, for example, a few months ago where one of the barristers was in New South Wales, one was in Melbourne, there was a witness in Queensland. It was absolutely seamless. The documents that everyone was being asked about were being shared on the screen. Everyone could see it. And as one lawyer said to me, it actually means there's no one sitting up the back of the court trying to follow what's going on and wondering what all the secret barrister speak is as they shuffle between documents everyone else can't see. So that, and the fact that all the country witnesses and perhaps the expert witnesses don't necessarily now have to come all the way into court, find a car park, wait till they can get on. Perhaps there's a problem, it doesn't happen till tomorrow. All those kind of things have been advantages. So I certainly think that as a court and as a justice system, we want to be making it as easy as possible for people to be part of the system, and having these sorts of benefits is one of the things to weigh up in the right matters.
Can I just give it, picking up from there, I'm in day 3 of a jury trial at the moment. So we've got the 6 members, it's a common law case. So there's 6 juries in our case at the moment. So this morning, the first witness gave evidence via video, the second witness was in person, and then the next witness was a medical witness and via video. And I expect the same will occur this afternoon. So it can be mixed up to the convenience of the witnesses as agreed by the party and the judge, and the jury is sitting there, and it makes no difference whether it's in person or remote. The trial proceeds really in a seamless fashion. So yeah, the mix up is certainly doable.
That's great, thank you. This question is from Tanya Bruckner, and perhaps a broader question. But will the continued and extended use of technology provide the County Court with the tools to reduce the case backlog, which has obviously been extended dramatically due to the COVID restrictions around criminal jury trials? This is probably more for you, Judge Marich.
It is. I'll compose myself. Now, there's a few things I think that come out of that. The first is that happily, in relation to the number of cases in every area other than jury trials, as I've mentioned, we didn't experience backlogs in everything other than jury trials because everything could keep progressing as we were used to. In relation to the jury trials, yes, by not having jury trials for the period of about 7 months last year, we did accumulate a large number of cases that have led to a backlog. Happily, that has somewhat been offset by the amount of case management we've managed to do in the meantime. Yes, some of the efficiencies trade off against that, because by having judges doing more work remotely in relation to some hearings, it's managed to free up other courts so that we can, I suppose, redirect the number of judges and take advantage of the courtrooms that are available, the judges that are available, because they have a little bit more time, and focus their attention in relation to the outstanding jury trials. In my view, technology isn't necessarily going to be the answer, because when it comes to jury trials, with some of the modifications that Judge Tsalamandris was talking about, such as interposing witnesses to appear remotely where we can, my view in that area is that that is the work of the court that will, for the foreseeable future, continue to be, needs to be in person, particularly the jury. We can't do without that. We can't do without the accused and their counsel. We can't do without the judge. And there's no part of that that can readily be taken online. So the short answer is that there's no simple answer, except for the fact that other efficiencies have freed up the space and the physical energy to dedicate our resources more to jury trials. But yes, there's a long journey, an initially intense journey, and then that'll fall away back, hopefully, to the pattern of and pace that we used to see in due course. But we've still got a way to go before we reach that point.
I think, can I just, in relation to jury trials, and I've only had the experience, the one jury trial with iPads in our court here, but certainly pre-COVID, the Supreme Court of Victoria had been using iPads in some limited number of criminal jury trials in that court, and it was only a limited number, so there's no empirical evidence to support this. But my understanding is the judges of the Supreme Court and the OPP involved in those trials reported that with iPads, they were running about 25 to 30% quicker than traditional trials. So the jury are all sitting in the courtroom as normal, but the use of the iPads, the two reasons why they think they're able to run quicker is in part not wasting time with shuffling of paper and hole whenever there's an exhibit. There's a lot of time wasted in hole punching and stapling and passing things out. But the other thing that I thought was interesting is the view of the judges I've spoken to in the Supreme Court as to why those cases are running quicker is that witnesses can sometimes be more efficient in their description of an event when in front of them they have a screen with the video footage or the photograph, and they can then all in the courtroom so that everyone can see, they can zone in on where they say a particular incident happened. They can mark with their finger where they walked. A screenshot can be taken, that can be tendered, and the jury have got it instantly. And that efficiency in describing things with those visual aids, which are interactive, is thought to be one of the reasons why those trials can proceed quicker. And again, there's no formal studies on that, but that was their view, that murder trials in the past that have been running, I think, 5 to 4 weeks, were coming back to, say, 3 weeks. So I think there's some hope there that we can potentially roll that out in appropriate cases here at the right time.
Yeah.
Thank you. Another anonymous question. What has been your favourite and least favourite piece of technology in court, and why? So you, Judge Tsalamandris.
Favourite? I love marking up court books on my laptop, and then just knowing if I need to work at it at home, I don't have to cart things back and forth. So I use a product that works for me. I can search a 10,000-page court book very easily to find particular words within it that are relevant to what I'm writing in a judgment. So I would say the ability to be able to search electronic court books and mark them up, I love the most.
This is a pretty minor one, but simply being able to correspond with my associate and my tip staff electronically without doing any of the sort of theatrical announcements that judges used to do, like tap pens to try to get associates' attention, which I always thought could come across as a bit patronising, or, you know, excuse me, which is also a bit unbecoming, especially if evidence is in the running. If you need to ask a quick question, for instance, in relation to an exhibit or 100 other things that come up in the running, you can just send a quick message without even raising an eyebrow. So as simple as just sending a message, which we used to not be able to do before, and Judge Marks was touching on this. The fantastic laptops that we have now, which we received just before the pandemic, I don't know if that was the heralding of the pandemic to come, we didn't have before. So even if we're having this conversation 18 months ago, we'd be getting out the big court desktop to send a message. So it's just so convenient to send messages.
Yes. I think all of the technology has worked together very well, and I've been very, very assisted by an excellent technology team at the court. But my favourite piece of technology, and don't want to sound like I'm spruiking Apple. I happen to love my iPad. It's an A4 sized iPad and it does all the sorts of things Judge Tsalamandris was just mentioning, but I can get in hundreds of pages of submissions and thousands of pages of documents the parties say are relevant in court book. I can get in all the different legal cases they're all sitting on one screen. It's A4 size, so I can treat it like a piece of paper and I can find things very easily. And that, together with the rest, has been a real wonderful. So I had it already before COVID came, but it has been even more invaluable with that.
Okay. How does the use of technology impact on open courts?
Well, if I can say, I think one of the things that I've found interesting is that anyone who wants to can continue to ask to join. You always used to be able to just walk into a courtroom unless there was some kind of suppression order. And so can people turn up and watch any hearing unless there's a suppression order. It's just that it's a matter of asking the associates to the judge for the Zoom. Anytime anyone's asked for that, I've always said yes. Again, the only reason I see there'd be to say no would be if there was a suppression order. In fact, it would be improper, I suspect, otherwise to do so. I think that's something that's perhaps not as widely known as it could be, but that is available. And I've certainly had students and other people join in. Sometimes more junior barristers have been interested. But I think I've found that often there have been more people joining electronically than might have come into the courtroom because it's easier for them. Instead of having to drive into the city or somewhere else, get parking, come in, etc., if they're interested in seeing the case for some reason, they can join in that way. So in that sense, it's technically made things more open, but I'm not sure if people are aware of it.
Yep, that's it. Yes, I couldn't have said it better.
Yeah. Look, the Supreme Court have the capacity to do live streaming of court hearings in a way, I think it's fair to say, beyond this court. We have done some live streamings on occasion, whereas I think the technology at the Supreme Court, whatever their facilities are, they can do that more readily than we do here. But I think going forward, that would be a good thing to do to even make it easier for people to come into courts without having to ask, because I'm the same. If people ask, I've certainly sent the invite, or my associates have sent the Zoom invite, but to be able to just log in and do that live streaming, I think is, highly consistent, obviously, with open courts legislation.
I think the one PS to add to that is we've always been very conscious of where we get written documents ahead of time and there are people participating, and to some extent this is even the accused. I think that there's a danger of the lawyers and the court falling into the pattern of, because we know the facts so well ahead of time, because we've seen all of the documents, that if you don't think about it really carefully and make sure that you're going through each step and making sure that everyone has the opportunity to emphasise exactly what they would like to, there's a risk that people might see some courts as being overly compressed and not dealing with all of the material that, now it's been a long time since we didn't have any submissions ahead of time, but there's a risk that the written page overtakes what goes on in oral discussion, but that's nothing new to technology. And judges are, because it's nothing new, are conscious of the fact that every step needs to be seen to be done, even if it turns out that everyone's talking about something that's been known for a long time.
Yeah, and can I add, I entirely agree with Judge Marich. I think it's ever been a problem and it's something judges are aware of. And I've been heartened to hear from people who are observing in court that they've found it easier, because now when we talk about a document, I'll have the screen shared and people can see the they can see the picture that's being talked about. They can see the argument that's being run. The feedback has been that they feel more part of it. It's not, as I said before, secret barrister's business going on at the front, but there is that awareness. The other thing that's been relevant to that is sometimes, for all the preparation people try and do, something comes up they hadn't prepared for, so they haven't yet got that document there. I've found it's actually been more efficient that you can just stand court down for a few minutes and they circulate it to everyone, than when they have to used to run back across the street to chambers and go and get it, or try and find the book and then come back. So that might not always be the case, but that's been a bit of a levelling for me where other people can see it as well very clearly.
Thank you. Anonymous question. Not everyone has access to technology, especially those on low incomes, or are uncomfortable using it, especially for something as important as being in court. Are people given an option to use technology or not, or are they given any help to overcome these problems?
Absolutely. Well, I can certainly say from the Common Law Division, for people, particularly during the pandemic last year, those that didn't have a device that they could appear on to give evidence, we had facilities here in the registry of the court so that people could come in and could use a device if they didn't have one themselves. So that was the way I think we probably dealt with that in that pandemic time. Going forward now, of course, because we've got people who are able to come back into the court building again for cases, there's no obligation on them to be giving evidence remotely. So in that sense, if they're comfortable to come into court, they can come into court. And if for whatever reason it's a matter of giving evidence remotely, or anything like that, there was the capacity down here in registry. And for self-represented litigants, there was mention before about e-filing. So documents in this court now are electronically filed, but if you're a self-represented litigant, there's no requirement for you to do that. You can do it in the traditional way, if I can call it that way. So it's not a matter of shutting people out. The court, I think, is very conscious of ensuring everyone can access justice, not just people with laptops. So hopefully we've dealt with that.
When we were in the, if I can call it the more extreme lockdown, was it lockdown 2? I lose track, but where it was 23 hours a day at home and only leaving for certain reasons and all that kind of thing. There was a couple of occasions where I just adjourned a matter over because there was someone who just said they could not manage. Yeah. One in particular, I remember, was at home with young children. Even though he technically had all the documents on his computer, he said, I'm not going to be able to concentrate on this case and deal with it when I've got my small children running in and out. And he didn't have someone else. That seemed reasonable to me. The case was adjourned off for a little while. So, and I know those sorts of decisions were being made all over the place. So it wasn't a case of, right, just manage regardless. The court was, as ever, weighing up these different things.
In crime, during the entire period and every day of the week, we assume that many, if not most of the people coming before the court are marginalised in some way. So crime just continued. So the only way in which a remote hearing could take place was if everyone could participate, because it comes back to a procedural fairness concept. If the accused or even one of their legal representatives doesn't have a device with adequate Wi-Fi or internet, then they're not fully tuned in, then they can't pay attention. We just do it in person. And the courts, there were always courts that were big enough every single day of the week to run in person rather than remotely. So no one should take from this discussion that we ever closed the court. That was one of the misconceptions of crime, that we stopped sitting for some reason. I think that there was some in the community that thought that because we couldn't hear jury trials that judges took 8 months off. We just kept judging every single day of the week, and that involved a lot of in-person appearances, and there were always exceptions for those sorts of matters. And if you sit in crime or if you appear in crime, this is sort of so obvious, it goes without saying, but every person who was linked in via their home, via a phone, seemed to have a pet or a child running around or sitting on the lap, or we just made it work unquestionably. And if there was any issue with respect to a person not being able to participate and feel like they were a participant, the court hearing wasn't valid. So if it couldn't proceed in person on that day, then it would end up being adjourned for long enough that the person could safely appear in person or safely appear privately with adequate internet, which just make it work.
Thank you. This question is probably more for Judge Marks or Judge Tsalamandris, and the question comes from Upwey High School. What is the biggest effect COVID-19 has had on civil courts?
You go. No, you go.
I was just going to say, I think probably echoing what I said a little earlier about, I think there's been far more awareness from the judges who were less comfortable with technology before, and there's been a real range on the court of how useful it can be in certain occasions, and the same from many of the lawyers and those attending. So I think that we will keep what we've perceived to be advantages, and keep trying to do that in a way that otherwise wasn't happening. It's brought it to the fore in a way that I think is very good for the way that the system operates. What about you, Judge Tsalamandris?
Yeah, I think the use of people being able to give evidence remotely, before COVID, it tended to be an interstate or overseas witness, leave was required, there was a general reluctance about it. Whereas now, I think for many witnesses, particularly professional witnesses, I think the default will probably be that they give it remotely. And then I also think for applications, pre-trial, directions hearings, I think the default for them will also be to do it remotely. So, and that is a big change. We used to require people to come into court and appear, and we've talked about people sitting there at length until their matter was brought on. And I think the Civil Procedure Act governs us in the management of cases in the commercial and common law lists. And if there is an efficiency there through technology with people appearing remotely in the ways I've just spoken about, that's entirely consistent with the overarching obligations within the Civil Procedure Act. So I think it's certainly here to stay. We won't be going back to everyone being in person in the way that we used to.
And what we've realised is it's not inferior. It's in many occasions, it's either just as good or there are other benefits. Obviously, on some occasions it's inferior, but it's not across the board. Sometimes it's even better. I've had witnesses from all around Australia and indeed across the world, and they're the only one on screen, whereas everyone else wasn't. And it's all worked very well. On a side note, we've had, I think, about 1,000 different school students join in and see different aspects of what's happening in the court. We always used to do a meet the judge where groups of school students could come in and talk with a judge before court, watch a trial, that kind of thing. We've moved to doing a lot of that through Zoom, and we've had students from all over the place being able to be part of it. So it's useful in all different ways, not just for court itself.
Thanks, Judge Marks. And I guess to that end, we received the question from Simone. How has the court facilitated court attendance for teachers and students? And I'll provide a quick answer to that. We've had more than 1,000 students attend sessions remotely thus far, which has allowed courts to engage with more regional schools than ever before. Another question, which is probably more for Judge Marich, is what kind of impact has online hearings had on sentencing and other aspects of the judicial process?
It's had no impact at all. It just happens online. Yes, I mean, I can go through the various aspects of how people are sentenced, but suffice to say that it can happen at the conclusion of a plea in mitigation of penalty. It can be adjourned to a later occasion, but in any event, it's going to happen. Just as night follows day, a person will be sentenced following a plea in mitigation of penalty. It's just done it online rather than in person. And now we're seeing them back to in person because a lot of parties, including victims, including other community members, feel that they do have that vested interest in the physical presence in court. So it's partly historic, it's partly philosophical. So now we're starting to see the return to in-person sentencing as well, where we can find courtrooms that aren't being used for jury trials.
Thank you. Okay, we have time for one last question. Where do you see court technology heading in the future? I'll start with you, Judge Tsalamandris.
Oh, really? Can I pass on that?
I'll jump in because I've got a few ideas, and I think it might be because I watched too much Star Trek or something when I was young. But I look forward to the day when we have screens around half the courtroom, and so everyone who's appearing either virtually or in person is the same size. We're possibly even using holograms in that way. I look forward to the day when people who are trying to find out what's happening in their court case or learn about the court can go on their phone and do it via different apps. I look forward to the day when rather people who are trying to tell their story and maybe don't have lawyers writing out their own version of an affidavit, and it'll have a whole lot of stuff that doesn't really assist because they don't know what's relevant. They've got an app that leads them through all the relevant questions, you know, like when you go and apply to get a ticket to fly somewhere, and you just get led through some kind of web chat. I think there are all kinds of things that we can keep learning about and using and doing that will make the system even better for people. But there you go. That was my thought.
I love that.
I think so. So I think in crime, this can be one of the takeaway messages from Star Trek to Kill a Mockingbird and 12 Angry Men. I think that there are some parts of the criminal justice process that we'll see are assisted by technology, but will always return to the idea of that in-person appearance and the in-person persuasion. So it might be distanced one way or another, but what we've learned about this whole cycle of not sitting in jury trials for some time is I think that there's always going to be a place at its core in crime for that in-person advocacy, which is interesting. But I think exactly as has been said all the way along, the form in which that'll take and the sort of little accoutrements of how evidence is called and all of that sort of thing, how judges are corresponding with their staff is going to be assisted by the speed and technology for sure.
Yeah, and so far as in-person advocacy goes, I think it's really important to remember that advocacy comes in a lot of different ways. Sometimes it's someone standing right in front of you saying something, but sometimes they're on a screen saying it. Sometimes they've gone to the trouble of thinking very carefully how they'll write it or how they'll present it in some other way. Advocacy in the end is about persuasion. So it's just a question of what technology we're using to let people persuade us one way or another of what is the just outcome. But I think the title of this session should have been from Star Trek to Beyond or something like that. I like that.
Thank you, Judge Marks. Okay, I'd like to thank Judge Tsalamandris, Judge Marich and Judge Marks for this great discussion, and say thank you to everyone who attended and asked great questions.